Good evening. I'm Norman James, and this is part of the Legal Aid History Project that's sponsored by the Connecticut Bar Foundation. We're doing this group interview here with the folks you see here, plus two on the telephone. All of us were involved in legal aid in Connecticut in the very earliest years, and we're hoping we can have a group conversation about those years and what we did and why we did it, and begin part of this recollection of legal aid in Connecticut. I'm going to ask each person here, and then the two on the phone, to introduce themselves, give a little bit of a brief history of their involvement with legal aid, and then we'll end up with some general conversation. So, start on my left, Judge Gill.
Okay, my name's Charlie Gill, and around March of 1964, I accepted a job with a non-existent group called New Haven Legal Assistance Association, and came back home to my hometown, which is New Haven. And I think I was chosen because I was, in Frank's words, an outlander. I was not an outlander. I was from New Haven, and actually from one of the rougher neighborhoods. So that was a pleasure for me to come back with my wife and newborn child. So we opened up on May 1st, the first Neighborhood Legal Services office on Congress Avenue. We had some problems with the bar, which you'll probably hear about in a moment. And fortunately, Professor Joe Goldstein at Yale Law School knew somebody called Justice Arthur Goldberg of the United States Supreme Court, who was kind enough to come down and cut the ribbon. And so my wife didn't have to worry about arrest, because part of the bar wanted to have me arrested for the illegal practice of law by a corporation, the Ford Foundation. So from then on, I learned a lot. I loved the neighborhood concept of legal services because it taught me, and it's forever indelibly put on my whole character.
And let's include a little bit about how long you were with legal aid, sort of where your career went from there, if you can.
Yeah, I was 2 years there. The first year there, one of the arguments from the bar was there wouldn't be enough business for us. The first year, my secretary, Janet Black, and I handled 1,500 cases, okay? And I virtually lived in that office. I was out there with my chairs at night. People would come by and chat with me. And I was invited to their parties, to their baptisms. I knew everything that was going on in the neighborhood, good, bad, or indifferent. They trusted me, and I really loved it. And after that, I went into private practice for some years. I made a stab at politics, which was a stab in the heart. And then eventually, I was the chief public defender for the state of Connecticut. And then I've been on the Superior Court bench now for 30 years. So I'm starting to learn the job.
Good for you. Thank you. Frank.
My name is Frank Deneen, and I really started with legal services going back to January 2 of 1963, which was the time that the Ford Foundation made money available to a social service program that was just being started in New Haven called Community Progress, Inc. And that program had a neighborhood lawyer concept to it, and so there were two neighborhood lawyers that were hired to work in that program. One was Gene Kahn, and one was myself. And after about a few months of working in the program, it developed that the work of a lawyer in a neighborhood where there was a great need for legal services simply didn't fit within the ambit of a social service program. Acting as advocates for clients, we did things that the social service program found were counterproductive for what they were trying to do. And so our program, the neighborhood lawyer program, came to a halt. But the Ford Foundation that was funding all of this thought this was an extremely interesting development. And they decided that it showed two things. One, there's a big need for free legal services in the community. And two, it has to be independent of any social service program. It has to be run by lawyers who understand what lawyers do. And so they added more money to the pot that they were giving into New Haven to create a new program, which was called New Haven Legal Assistance Association. which was strictly a lawyer program, a legal service program. And while this was developing, the city was interested in what we were doing. The city was running a municipal legal aid bureau, manned in large part by law students from Yale. And the city agreed that ultimately it would be willing and actually desirous to merge the two programs into one. So at that point, I left Community Progress and was appointed by Mayor Dick Lee to be the director of the Municipal Legal Aid Bureau. And I did that for a couple of years. Actually, Charlie Gill joined us when he got out of law school and one of the lawyers working there. And it then developed that after 1 year of practicing on my own, I became a teacher and a mentor.
Right.
And for all the new lawyers that came in, was one of my roles. In 65 or 6, I believe it was, the two programs merged, and we had the one New Haven Legal Assistance Association that performed all the functions of the Municipal Legal Aid Bureau, as well as the various functions of the neighborhood offices, of which Charlie was operating one throughout New Haven. Fred was the executive director of New Haven Legal Assistance during the time that we started up, and I'm sure he will tell you about the opposition that we got from the private bar at that time, claiming that we were doing things that were unethical. We were advertising when we probably shouldn't have been, they thought, and that was unethical. We were going to take away their business. And so there was a great deal of opposition to the program. And initially, they, from the New Haven County Bar Association, voted us down. They voted that we were not needed. There was no need that had been demonstrated for legal services in New Haven. And that in any event, they could satisfy that need themselves, and they didn't need a new program. At some later point, they reversed themselves, but in between, the State Bar Association approved what we were doing, and so we were able to continue on. So I've been working at New Haven Legal Assistance really from the beginning till the present time. I still work there. I work there on a part-time basis. I teach also at the Yale Law School in a clinical program in which we bring cases over from legal aid to the law school for students to work on and appear in court on under the supervision of attorneys.
And Frank we need to make sure that people understand that Frank probably is unquestionably the dean of legal aid lawyers in the country, because there may have been a few others who may have started before he did, but there's none that have stayed as long as he has. So we're proud to have him here in Connecticut.
Thank you, Norman.
Fred, why don't we go around and I'll pick up the end.
Okay. I started in September 1964. I'd been teaching law school in Washington, D.C. I spent some time as a federal prosecutor and also at a big firm. And one thing is clear, that when I came here under this new Ford program, I really knew nothing about law and poverty. And you can understand, because in law school we deal mostly with appellate cases, and in the practice I had, we were dealing with that. As a matter of fact, from the late 1800s until the late 1960s, when legal services started around the country, no legal aid lawyer had argued a case in the U.S. Supreme Court. Immediately on getting here, we did run into the problem of the bar after a result of 2 meetings, both of which I was kicked out of. They did vote us down for the reasons given, and also there was a claim that we were a corporation practicing law, New Haven Legal Assistance was a corporation. It had employees. They practiced law. But like any legal aid bureau or indeed a public defender, the corporation doesn't get involved in the practice of law. The attorneys file their own appearances in court, and it's the attorneys who practice law for their clients. And that was ultimately upheld when, after the Bar Association in the fall of '64, referred it to the unauthorized practice section of the Connecticut State Bar Association, which found that we were not involved in the unauthorized practice of law, and indeed were operating in the best traditions of the bar and legal ethics. And that came down in the early spring of '65, and then, as Charlie has mentioned, on May 1st, 1965, the Congress Avenue office was opened and soon had many clients. And from that point until the late '60s, legal services around the country was really on the rise. The other Connecticut programs all developed around the country. A lot of them had neighborhood offices which were coming on. Richard Nixon was elected president in 1968, I believe. Donald Rumsfeld was his first head of the Office of Economic Opportunity, and from that point on, and then Governor Meskel became governor of Connecticut, legal services was cut back. There were some that wanted to eliminate it altogether, and there were others that settled for just cutting it back. Because by then, the federal government, modeling its program after the New Haven program, started investing millions of dollars across the country in
Brad, you
legal
keep
services.
fading out.
Okay, I'll try to speak up, I'm sorry. The federal government had come in the late '60s and had funded these programs with millions of dollars, and they were up all over the country. But then starting probably around 1970 and through the '80s, it really got cut back. I think by 1980, Frank will know better than I, perhaps others here, neighborhood offices really went their way, and legal aid really retreated to a central office, which they'd had prior to all of this, although they were much better staffed. I'd just like to make two observations, and they're almost in the nature of questions. I believe in the late '60s, at the height of New Haven Legal Assistance, when we had 30 lawyers, 5 neighborhood law offices, a law reform office, and a group counsel office, plus the central office that Frank was running with 3 or 4 lawyers. We handled about 10,000 cases a year. The New Haven Legal Aid Bureau today, which serves towns as well as New Haven, handles about 1,000 New Haven cases a year. Query. The New Haven Legal Aid Bureau, I believe at that height, when all of the offices handled 10,000 cases, 2,500 of those were at the New Haven Legal Aid Bureau. Now down to 1,000. Query. Is it the neighborhood law office concept? And then the second observation may relate to that. Shortly after opening up the Congress Avenue office in the storefront that Charlie opened and ran, we opened a second office several blocks away on Grand Avenue, and another, still in the Hill neighborhood. New Haven's divided into these poverty neighborhoods, several blocks in the other direction on Dwight Street. Each developed their own caseloads, close to what Congress Avenue had done, and the clients usually came from very close proximity to the offices. So it's not just a neighborhood office accessibility versus downtown, it's within a mile or so of each other. You see this proximity, and I throw both that out and the overall statistics of caseload really to the others to see what their experience
Well, let's see if we
has
can.
been. And I left in 1974.
I'm sorry, thank you. And his name is Fred Danforth, for the record.
Yes.
Junior.
Junior, thank you. Jim?
I'm Jim Trowbridge. I joined the Legal Services War on Poverty in, I guess, November of 1966, but then I had to go away for 6 months. for the usual reason. And so came back in June of 1967 and as a staff attorney. The early days of the program were made easy because the way had been shown by Fred and Frank. And
Jim, you need to tell us where you were.
in Bridgeport. We had 4 offices in Bridgeport. We didn't have a lot of bar opposition. In fact, our board, as perhaps in New Haven also, was made up of what would be called bar leaders. And Jack Sildes, Al Belinky, David Jackson from Pullman, Peter Wilkinson from Marsh Day, as well as lawyers from smaller firms, Howard Owens. And so we didn't have that kind of organized opposition. Now, there were people who didn't welcome us in town or necessarily in court, but we survived. We followed the neighborhood legal services template. As established in New Haven, we had 4 offices, neighborhood offices. We shared some with the CAP agency, the Community Action Agency. They were pretty good at sending cases to us. What we discovered is there was a vast inventory of failed marriages. There was a stock of about 20 years of failed marriages. And so the program was overwhelmed with these divorce cases. In those days, there was not no fault. I mean, you had to go up to the courthouse and testify, and the client had to testify. And suddenly she started smoking a lot or putting on weight, and you needed 2 witnesses. And so a lot of time, in a sense, was diverted from the ideal of law reform. And boy, did we feel that in Bridgeport, because New Haven was so good at it. New Haven had a law reform unit with Dave Lesser and Bill Clendenin and Stuart Baer, and you probably had some other worthies, and I don't mean to overlook them, but you know, that was the racy brigade up there in New Haven. Here we are doing divorce cases. And but we had no real opposition, and I became program director in 1969. We had a group called the Project Directors. We used to meet at the Graduates Club and share war stories, or you know, our dealings or difficulties with the OEO or all the rest. But I left in 1973 and was in private practice for 6 years, and then joined the law faculty at the University of Bridgeport and became director of the clinical programs at Quinnipiac. And I went emeritus. That means, you know, they don't expect to see you around
Don't
very
tell them
much.
me.
And I guess in June of 2006.
Thank you, Jim. Miguel?
My name is Mike Ayala, Miguel Ayala. I started with legal service in Bridgeport October 7th, 1971, right out of school. My first boss was Jim Trowbridge. I started working at the East Main Street office, which was so neat because I lived around the block. So I could pretty much literally just walk around and I got to the office. And that was kind of like the start of what has led me to become a part of this great program, legal service, because I've been there for almost 43 years. It has changed in different ways, but one of the things that I remember about the local program and the way where it was situated was that we were very much connected with the folks we represented. And I remember times when we would actually meet with folks early evening. I remember being out there sometimes 8, 9, 10 o'clock with these folks because there were issues that had to be dealt with, and it took us out there at those times. But there was this connection and this trust that you mentioned, Gil. Yeah, that it was that bond and that connection with the community. I don't think that is so true today. And maybe I don't know all the reasons, but there's been some changes, you know, throughout legal services, and And Frank, you mentioned the numbers of cases and what have you. Of course, we have to look at one of our programs, Connecticut Legal Services. At one time, we had, like, Norm, you correct me if I'm wrong, we had like 13 field offices, and we're down to about 6 offices. And that had a lot to do with the cutback. We were drastically reduced back during the Reagan era. And the history there is that Ronald Reagan didn't like legal services. And it was evident by what he did to legal services. And I think that it hasn't really recovered since that time. I really believe that. We've never recovered from the Ronald Reagan era. And then now, as it has evolved in that right now, presently, I work for a program called Statewide Legal Services, and we run a legal hotline. And if you talk about changes in legal services, and that had a lot to do with, again, with the cutbacks and the restrictions that, not only have they reduced, like funding, but also many of the restrictions have come down. And I think that I don't believe that legal service will ever be the same. Sadly to say, I don't think so. And I've been around so many years, and because I see more and more folks that run these programs reducing funding, the politicians and what have you. And so that it's saddened me because the issues are still there. There's, in a state that's supposed to be a state so rich, but yet there are many poor folks in this state. We also now are receiving from what happened back in 08, we're representing folks now that lost their home, they lost their jobs. And that's another tier of people that are coming to see us now. So it's not only those folks the poor population, but these are folks that are now reaching out to legal services for our services. The demand is great, as great as ever.
Thank you. Now, we have 2 disembodied voices that we need to hear from. We're not quite sure how this is going to appear on video. We will try to be interested and look alert. Let's start with Howard Ornstein. Howard, can you give us your brief history?
Yes, I'm having trouble hearing all the speakers, so I don't know. Can you hear me okay?
We can hear
Yes,
you
very
fine,
loud.
yes.
Oh, okay. I'll follow along the pattern of what I've heard so far. I spent my first 2 years in private practice in Fairfield County, actually in Bridgeport and Westport, and then I left private practice. I sort of went the other way that most people went, and went into a legal aid program in Hartford, and worked first for the Hartford Legal Aid Society, and that was then run by Bill Graham, who I would say, if he were alive today, would certainly be in this group as a pioneer, because I learned so much from him, and I still think of him all the time. Then, when Legal Services was funded by the Office of Economic Opportunity, Bill became the named director, but in fact he was then quite active in running for, I think it was either Attorney General or State Treasurer, and so I ran the Hartford program for essentially starting in '66, having been with Legal Aid from '64 to '66. The issue of the bar, there was initial skepticism of the bar, but I think that very much like what I heard from one of the other speakers, we had some wonderful supporters, in particular John Newman, who became, of course, a federal judge, Nick O'Neill, who became a state judge, Bob Satter, who became a state judge, and Bill Graham himself. And the work with the bar was done by the time I started. And the way that the program was structured was that we had a board which included representatives of the bar and also of the Legal Aid Society and of the Community Action Program and of the neighborhood people. It was a very a new thing for me, and it was a new thing for the law itself. After that, and after the eligibility guidelines were worked out, and the fact that our program would handle no contingency personal injury cases, the bar was in fact about as supportive as it could be in terms of our program, and particularly in terms of lawyer independence. The Community Action Program members and the community members were very important to us in orienting lawyers, that is myself and those who worked with us, to the true conditions and to the attitudes that were felt by our client community. And that, I think, together with our presence in the neighborhood itself, was really what made the program and gave it its quality. Also, we had an initial presence in a multi-service center in which we collaborated with, I can't remember how many, but quite a large number of agencies, state and local agencies. And that collaboration, while it was somewhat, there were some suspicions in the beginning because, of course, we would be suing some of these people. We actually all worked rather well together, and a lot of issues arose because of that collaboration in the uncharted legal areas that had been neglected for so many years because of the absence of the type of program that we were running, including what I know I heard about the New Haven program, the law reform. Our law reform, we didn't have a separate law reform unit. Our law reform grew out of our daily services, and we were broken down into categories of law. And so that was our initial beginning. I think the only main comment that I want to make is that there were people who, like the people in this room today, who gave everything they had. Bill Graham being one of them, and after me, Sid Shulman and Mary Hennessy, who became also a judge, were people whose dedication was just so inspirational to me that I felt privileged, really, to work for the program that I did work for. A few of those people, I think, were very important. One was Brian Hollander, who argued the first U.S. Supreme Court case by a legal services program in the country, which was Shapiro versus Thompson. Very important. Stu Schimmelman, who became a state court judge. And in fact, very, very recently, I heard from Tim Fisher, who's the new dean of the University of Connecticut School of Law, who served as a clerk for the program during one of the summers. Elliot Milstein, who became president and dean of the law school at American University, and Eric Coleman, who's been a long-time Bloomfield state senator. In other words, the point I think I would make is that the graduates of our programs have taken important places in the bar, on the bench, in legal education, and in government, and that's been a very, very important thing, I think. The other side, obviously, is what I heard. I didn't get the name of the speaker who spoke after Jim Trowbridge, who works for statewide legal services. I couldn't hear, but that was a very sobering presentation about what's happened since those days. But that would be my statement about what happened in the early days of Hartford.
Howard, tell us quickly how long you stayed with the program and what happened in your life after that.
I stayed with Legal Aid for 2 years, 64 to 66, Neighborhood Legal Services 66 to 67. Then I went to the Commission on Human Rights and Opportunities, where I was their general counsel for 8 years, from 67 to 75. During that time, I sat on the Hartford board and, in fact, was the chairman of the board for a time. And then I went back to Neighborhood Legal Services in 75 to 79. And at that point, I left for legal education in California, which is where I am today.
Thank you. Bruce, tell us your story.
much time do you have?
Make it short.
When I got out of law school in 1966, I was the first employee hired by Legacy, which served New London and Norwich area. My first boss was Jack Donahue, who, because he was trying to get reciprocity from New York, was not able to practice law in Connecticut during virtually all of the time that I was there. So I was kind of thrown into the fire, making all the appearances. After about a year and a half, a woman who I had dealings with, who was a social worker, told me that her husband was a lawyer in Willimantic and that they were starting a program, and would I please apply to be director, which I did, and I guess nobody else applied, so I got hired. In New London and also in Willimantic, there was some significant opposition by members of the bar, although in New London, we had as a member of the board, and he might have been the chairman, I can't recall for sure, was Morgan McGuire, who was a former Republican state senator who was a very strong supporter. So that kind of took a lot of the wind out of the sails of the opposition. I was at Toll and Wyndham legal assistance from roughly late '67 through the middle of '61, at which time I was encouraged to leave by then Governor Meskel. I think Fred may have been talking about Meskel early on. What happened was that our program had sued the state so many times that Meskel then sought to block the funds that we were getting through a state agency, through the bond commission. And when he did that, we sued him, at which point he began to not only attack the program, but attack me personally, being young and foolish as opposed to now old and foolish. I responded in kind and soon realized that if I wanted to save the program, I had to leave. I actually hired a few interesting lawyers for that program. Probably my best hire was Norman. I also hired Ed Dolan, and I think I recommended him to you, Fred, and you then hired him in New Haven. And at one point, I believe I had Ray Norco working in our program as well. We worked fairly closely with the New Haven Law Reform Unit, particularly with Bill Clendenin. Bill Clendenin was the person who sponsored my application and admission to the Supreme Court. After I left Willimantic, I traveled for a summer and ended up directing the legal services program in Phoenix, Arizona. Well, if I thought it was difficult being in the state with Tom Meskel, I was just getting warmed up. I lasted there for about a year, And then moved on to the San Mateo, California Legal Aid Society, where I was a litigation lawyer for about 4 years, maybe 5. And then I was getting a bit burned out and decided to take a civil service exam to become an administrative law judge for the state of California, and was hired for that. Stayed there for about 30 years. They improved the working conditions significantly during the first few years, and something that I thought was going to be a way station turned out to be fairly permanent. In the early 90s, I started teaching also at Santa Clara Law School, teaching employment law and employment discrimination. And just recently, I started volunteering at CRLA. The old-timers probably know what that stands for. It's California Rural Legal Assistance Associate program, and I've learned in my short stint there that the money is significantly reduced, and that the amount that can be done is substantially restricted because of the cutbacks in staff and in funding. So that's about all that I can think of at this point. I retired from the law school around 2006 or 7, and I retired as an administrative law judge in 2008.
Thank you, Bruce. And for the record, that's Bruce Burwald. We didn't get your last name. Let me briefly introduce myself. Again, I'm Norman Janes. I started my legal aid career as a law student. I think that in perhaps December of 1966, worked with a staff attorney at the Legacy program in New London, a guy named Bruce Burwald. Did some kind of research project. We got to know one another. When he moved to Willimantic, still as a law student, I went to do some work there. I think I spent a day or two a week. That was much more interesting than being in a classroom. Bruce hired me when I graduated from law school in '68. I was originally a VISTA volunteer, and I stayed there actually until 70 or 71. My wife and I took a sabbatical and taught at a boarding school for a few years. Came back in 74, started a project involving legal services to the elderly, and eventually when Connecticut Legal Services was formed, I went to work with them, became their executive director in 1980. When we started statewide legal services in the mid-90s, I became executive director of that, and I finally retired in 2008. Did some work with the Bar Association for a while, several times, and I am now finally retired full-time so that I can do things like help to organize this kind of a project. So I have a long history, and we can certainly talk about some of the administrative things. Fred.
Can you explain, you've got Connecticut Legal Services and statewide legal services now?
Yes.
Can you explain what each is and what each does?
Okay, well, they're now, in Connecticut now, there are 4 core legal aid programs. Connecticut Legal Services is the largest because it covers most of the state, with regional offices providing a traditional legal aid kind of practice. New Haven Legal Assistance covers the New Haven area, Greater Hartford Legal Aid, the Hartford area. Again, those 3 are what we would think of as traditional law offices providing a wide range of services. Statewide Legal Services was started in the mid-90s because, as Miguel mentioned, there are a lot of restrictions on the funds from the Legal Services Corporation, the federal money. and there was serious impositions I think it was starting in 1995. And we in Connecticut thought that money was about really less than half, maybe a quarter of the total amount of legal aid money we had at the time. And we didn't want that quarter to really limit and restrict what we could do. But we also didn't want to turn it away because it was over $2 million at the time. I can't remember the exact number. So we said, how can we use that money in a way which really will benefit clients but won't limit the kinds of services that we can provide to clients? And so we created a new organization, Statewide Legal Services. We were not the first, but we were very early on the idea that you really can provide some very helpful, useful advice to folks over the telephone about what the situation is, how they can help themselves if they can, and if not, make referrals on to Connecticut Legal Services, New Haven, and Greater Hartford. So that's the network.
So by doing that, you can take the federal money.
So the federal money, all
But
the
if you
limited.
want to be a real lawyer, you can't take federal money.
Well, yes, you can say that. I mean, the non-Legal Services Corporation funded programs do a wide range of services for clients, including litigation in court and a lot of policy advocacy, community activities, on and on. The attorneys and the staff at Statewide Legal Services only provide sort of analysis, advice, and referral over the telephone to clients.
If I walk into, say, the New Haven Legal Aid office now, like LAA, downtown New Haven, and apply to, I want a lawyer, can I apply right there, or do I have to go through some statewide office?
Depends,
It
really.
depends, yeah, right.
Ordinarily, they would tell you that you should go through statewide legal services. You could do that right from our office to do that, by phone, by fax, or whatever. If it was an emergency, we would probably do the intake right there. But statewide is basically an intake office.
I understand.
And set up to be able to capture all the money that would have come from the Legal Services Corporation. So the state didn't lose anything. We just rearranged what we do.
I'm just looking at the
May I make a suggestion here?
bureaucracy. of it.
We're off the topic of the history.
Okay. I'm
Okay?
sorry. I'm sorry.
May I return us back to the
Please
history?
do.
By giving you a case example. There was a guy named John in my neighborhood office. He used to come in every day and take pictures of me. He obviously had mental problems. Then I met his wife, and then I knew that he had mental problems. One day he comes in with his wife, and they're very upset. They had 3 daughters who were taken away by DCF in juvenile court, and they were trying to terminate both parental rights. Some of the evidence they had against him, he was a strange guy. In his bathtub, he had turtles. Okay, he had a picture of Joseph Goebbels on his wall. And so they took away his 3 daughters. And just to let you know, the viewers here, what it was like then and how much better it's gotten now in terms of respect. I went over to the juvenile court. I'm not going to leave everybody nameless here. And I went in, and I was ready to start to defend the parents. And I noticed that we didn't have a court reporter. So I said, Judge, I want a court reporter. He said, we don't use a court report here. I said, then you're not going to hear my case. I'll take an appeal. So he relents, and a court reporter shows up, step 1. Now they put on the witness from DCF or whatever agency it was, and she testifies about the Goebbels picture and the turtles and all this other stuff, and that these 2 people aren't the brightest whips in the world. But at the end, I said, he said to the female witness, whom I knew, said, well, you can step down now. I said, excuse me, Judge, I'd like to cross-examine her. Oh, no, cross-examine my witness, he said. I said, he's not really your witness, So he allowed me to cross-examine the worker and found out she was an English major in college. She didn't understand many of the terminology that she used in her report, okay? So that's how bad it was for us trying to get through the doorway into the courtroom and get respect. So a lot of these little things we did, all of us, have changed the whole concept of how lawyers for the poor are treated in the state of Connecticut.
Yeah, let's focus on some of the early cases and clients. More stories like that. Anybody? What's your favorite client story?
Well, maybe Miguel can talk about the young lords.
Yes, the Young Lords. I believe that it was probably around early 70s, I was 72, 73 maybe. The Young Lord Party had an office on East Main Street, which is right across the street from our office. And what happened, it was this huge demonstration where probably, not to exaggerate, probably the whole police department from Bridgeport was based down there on East Main Street. I mean, they had their headgears on. I mean, it really became a pretty violent situation where a number of folks ended up in the hospital, many injuries, and what happened there, again, I had mentioned earlier, the connection, we became very involved in what was going on because a number of these folks that were injured came to our office, and I believe that, I'm not quite clear, and Jim, you may, I'm not sure we actually represented them, but I think we had some part in that.
Yeah, two things happened. The police apparently assisted marshals, or sheriffs in those days, in wrongfully evicting young lords from their offices. So
I'm sorry to interrupt. Would we call this a gang today, or was it?
no,
more-
they were the sort of, they were the Black Panthers.
They were
for
comparable to the Black
African-Americans,
Panthers, right.
and, we had some
All right, okay.
And so they were evicted. So they brought a wrongful eviction and detainer action. And I recall trying it before Judge McGinnis, whose son is now a lawyer in Bridgeport. And I do recall something very interesting. Counsel for the landlord started asking Wilfredo Matos, who was head of the Young Lords at the time, then went to work for CHRO, who the members were of the Young Lords. And I objected, saying it's not relevant. And Judge McGinnis, to his everlasting credit, said, yes, it's just like the IRA. They'll never tell you who the members are. It's sustained. And so we got them back in because there was, it was eviction by force of arms, and using an old remedy. And there was another occasion in the same intersection where the legal services office was, and you're on the east side,
Right.
where there, somehow or another, a crowd started throwing rocks at firemen. Perhaps because they ascertained there wasn't a single minority who was anything but the chief's driver in the Bridgeport Fire Department. So there was some sort of incident. All the police showed up. So there was this huge mob. And then it was a traumatic situation for me personally. I thought this mob needed to go home because it was going to be trouble. And I spied the police chief, Joe Walsh, in his car, and he had a megaphone. So I went and said to Willie, if I get you this megaphone, will you tell the people to go home? So then I had to go over to Joe and say, he said he's going to tell them to go home. So I took the loudspeaker and gave it to Wilfredo and thought, there's my career, let's see what happens next. And after making a couple of speeches and engaging some rhetoric, he told them all to go home, and they went home. So Pax Americana returned to East Main Street in Bridgeport.
It's good.
Howard, can you tell, you mentioned the Shapiro case. Tell us about that and something of the people who were involved, the clients. I think you said you were involved in that.
Yeah. Actually, I'll take a couple of minutes. When we started our program, as I mentioned before, we were in a multi-service center, and what that meant was that we had an office, and the state welfare department had an office, and city welfare had an office, police department, housing code enforcement, and so all kinds of people walked into that building. On the day that we met Ms. Shapiro, her case was not the most pressing. It was a young woman who came in who had bloody sheets. Her family, her children, had been bitten by rats because the landlord had decided to use a self-help eviction by taking all of their furniture, turning off the heat, turning off the lights, and leaving them basically on the floor, and they've been bitten by rats. That's how we basically had occupied the morning. And during that morning, Ms. Shapiro walked in. Ms. Thompson walked in. And the history of Shapiro was basically this. Just for the record, Shapiro is 394 U.S. 618.
Hello?
In New Haven had a case a couple of years before in which under the law at the time, the state was permitted to have the state police take poor people and put them on a bus and send them back where they came from. That was part of a law that preceded the law that we attacked in Shapiro. And he took a case in federal district court. That case folded because the state conceded that what they were doing was improper. And then they passed a new law. And the new law tried to do the same thing except in a different way by saying if you hadn't lived in the state for more than a year, you could not collect welfare, as a result of which a person who came into the state would be deprived essentially of the necessities of life and would be indirectly sent back from where they came. Ms. Thompson was living at the time in Springfield, and she was a young woman who had become pregnant, wanted to come to Hartford to be with her mother so her mother would help her. And she was on welfare in Massachusetts, and by the way, had a higher welfare benefit in Massachusetts than she would have gotten in Connecticut. The case came to us because a city welfare worker objected to the fact that the city welfare was not allowed to come in to a state welfare hearing and press for her state welfare benefits, thereby, of course, taking her off of city welfare. And so we got a call from the city welfare person, and the case didn't develop the way that we had originally thought, which was the question of whether the city welfare worker could be in the room, but based on the welfare residency requirement itself. Four of us, which was Brian Hollander, Sid Schulman, Stu Rosen, and Stu Schimmelman, worked on the case. And then I think it was something like 28 private lawyers, headed by Bill Mueller, who later was the state bar president, helped us to put together the materials which later became the brief for the U.S. Supreme Court. The case was argued before a three-judge court. I remember that Clary was a dissenter. I know Blumenfeld voted for us, and Judge Smith of the Second Circuit voted for us. So 2-1, the state statute was declared unconstitutional. And at the three-judge court level, there was some question as to exactly what the basis for it was. When it went to the U.S. Supreme Court, and I believe it was 6-3, there was even more of a question as to what the basis was, because one of the judges says it doesn't make any difference what the basis is, it's unconstitutional. But basically it was an equal protection argument, an impairment of the right of a fundamental right, and therefore a raising of the standard of review. And it became the first U.S. Supreme Court victory. There were four others that I can recall that were companion cases from around the country. One of the things that I found was interesting, other than all the help we got from the private bar, was the collaboration with people from around the country. We got calls asking for copies of our briefs, copies of our pleadings, and so on. And that kind of collaboration led to things like what was later called the Clearinghouse Review, where lawyers from around the country would send in their materials and their briefs, and everybody around the country would share in that. So we became a kind of a national, collaboration. And the backup centers which began to specialize in these things around the country. So Shapiro was really an exciting situation, and it started with this day with the people, the woman whose children had been eaten by rats, which gave you the flavor of it.
And I assume you were able to help her as well.
I'm sorry, I didn't hear that.
I said, I assume that you were able to help that woman and her family as well.
Yes, as a matter of fact, we sent her to Bill Gallagher, who was also a later state bar president, and he brought a suit in which he collected against, I don't think it was only against the landlord, I think it was against the city, yeah, but we did, of course we helped her.
Good.
She was the focus of the day.
Thank you. Anybody else sort of a favorite story, Fred or Frank?
Well, in terms of sort of the effect or the impact that we had in different areas of the law, one example is when we started practicing in the field of summary process and evictions, people were generally not represented at all, tenants who were being evicted from their homes, and there were generally no defenses being raised on their behalf. And we started appearing in those cases. And although summary process is supposed to be summary, that never is really clearly defined in the statute as to what that fully means. So we started to transpose all of the pleadings that were available to a defendant in any civil action over into summary process actions, so that all the various pleadings, the plea and abatement, the motion to erase, the motion for more specific statement, the motion to strike, the motion to dismiss, which is now abolished, but we brought everything over and litigated every case fully, and revealed that defendants in eviction cases had many defenses, not just procedural, but substantive defenses as well. People at first laughed at what we were doing. This was a novelty, unheard of. And then there was a committee of several lawyers that was appointed to review our pleadings that were on file in the court to see whether there was anything unethical or improper about the pleadings that we filed. They went through all of our pleadings on file in the court, not in our case files, but on file in the court, available to the public, and concluded we can find nothing wrong. And we proceeded on. But we basically changed or revolutionized the practice of eviction defense in Connecticut.
Frank, the most serious offense was embarrassing the lawyers for the landlords who couldn't figure out how to serve a notice to quit and pick out the correct dates, including the terminal date. We had quashed 3 in a row for a fellow who was the state senator in Bridgeport. He was a slow learner. And so that's all we did. I mean, it wasn't deleterious because it went to the merits. These are statutory cases and they depended upon exact correlation with
We
the
had
statute.
one case that won 11 consecutive writs over a course of 5 years
Slow learner,
before it was settled.
right?
Bruce, you were going to say something a minute ago.
This is Bruce. I recall several instances in which the landlord's lawyers, after having their complaints demurred to or stricken and so forth, would finally throw up their hands and say, just tell me how much time your client needs.
Right.
I'll make sure that they get it. But when Howard was talking about Shapiro versus Thompson, and he mentioned Judge Clary, that reminded me of a case that we had, Perez versus Tynan. It was a Motor Vehicle Financial Responsibility Act challenge, and we, in order to convene a 3-judge panel, you had to have a district judge order that. And unfortunately, we got Clary, who in spite of the fact that the law was clearly unconstitutional, refused to panel that 3-judge court. We had to then go to the Second Circuit, get him reversed. In the meantime, a case out of Georgia, which was raising the same issue, actually got to the 3-judge panel and got on the Supreme Court docket at the same time that our case was still in litigation. So we ended up cooperating with them, and that case effectively overruled all of the motor vehicle financial responsibility laws, which was another example of a case that was brought by, and there were probably other states that were involved in there as well, but I do remember the Georgia case, and I forget them. One of the names was Burson.
Right, it's the case is Bell versus Burson. And actually,
Yeah.
you know, I hate to correct you, Bruce, because you were my boss, but the case that we eventually filed in the Supreme Court, for which we got a per curiam, was Latham versus Tynan. You remember that when we were working on that issue, we had several clients, and eventually they got their licenses back. For people who don't understand, this was before mandatory liability insurance. And the law said that if you did not have insurance and were involved in an accident, that you were going to be required to post a bond to secure against any liability. And of course, our clients didn't have insurance because they couldn't afford it, and also couldn't afford to post the bond. The case, the Latham, I've forgotten his first name, but it really tells you how awful that was, because he was involved in a very minor accident, not in a public street, but in a grocery store parking lot. And I think everybody recognized that it really was not his responsibility. Somebody clearly ran into him, and yet he lost his license, and of course his job was in jeopardy, and so on. It was a serious problem that was affecting our clients. And as Bruce said, the Georgia folks beat us to the courthouse door, or at least to the Supreme Court courthouse door. But there is a per curiam decision, Latham versus Tynan, that lists both Bruce Burwald and Norman K. Janes as attorneys. So we're in the books.
I have a story.
Well, I stand corrected on it started out as Perez
Yes.
versus Tynan,
Yeah.
and it then morphed into Latham.
Right. Jim?
Legal service lawyers were not in fear of anyone. Two examples. One, when Governor Meskel, acting through the Department of Community Affairs, tried to put a condition on the state's local share. You had to, when you got OEO grants, 20% of the value of the grant had to be raised through non-federal funds, and I believe the state was contributing 10%. And then they attempted to put that restriction on that Bruce Burwald had mentioned. So the legal services programs got together and went to Charlie Parker at Tyler Cooper, and that firm brought suit in federal court. I guess our theory was somehow he was trying to restrict the First Amendment rights of our clients. And luckily, we got before John Newman, and even luckier, his clerk was Andy Hurwitz, who's now the Vice Chief Justice, there is such an office, of the state of Arizona. And it was settled. It never resulted in a decision, so if you research it, it'll be a blind alley. It was settled, and I think they dropped the condition. And then another case, Bridgeport got some model cities money, and that was around, and we started a criminal practice. And the first time we appeared in the Superior Court, the state's attorney sent our appearance back saying that in our court, public defender will represent people who can't afford counsel. Well, that was a very interesting development, that the state's attorney was now running a mini bar. So the program with the support of Jack Zaldiz, who was then our chairman, sued Judge Otto Lamacchia, the PJ in Bridgeport, in federal court. Now, don't ask me to this day what a theory was. All I know was settled over the weekend, and we got the privilege of, if you can call it that, of representing a few criminals in the Superior Court, JD, what would now be called the JD.
Well, I have a similar story in Willimantic, because Bruce had managed to secure a grant. Was this a state grant, Bruce, for the due to the criminal work? Do you remember? Do you know what?
Oh, yes,
Yeah.
when we hired Art.
Right. Anyway, we got a grant to do criminal cases, and we'd hired Arthur Meisler, who some of you will remember, but he was fresh out of law school, had not yet passed the bar, and Bruce, in his infinite wisdom, said, well, we need to start spending the money on that grant, so you, Norm, you're going to do this criminal work, which is not something that I really wanted to do. But anyway, we agreed, we got started, and the first defendant that I represented, and I can't remember what he was charged with, but I walked into court, and the case was called, and the state's attorney, I'm not sure they were called state's attorney in those days, but the equivalent, the prosecutor, when I stood up next to the defendant, said to the judge, Judge Bielik, said, Your Honor, I object to Mr. Janes representing this man here in criminal court. And Judge Bielik said to me, are you licensed to practice law in the state of Connecticut? Mm-hmm. I said, yes, sir, I am. He said, that's good enough for me, let's go. And that ended that opposition. But there was...
I have a story of a client, and I mentioned earlier, back then, the connection that we had with the community. And I remember I represented this gentleman in a Social Security disability case, and I got to meet his sister because she was involved with the community, and she was telling me the story about her brother who was suffering from seizures, epileptic seizures. But what was happening, this gentleman lived with her. When he would get these seizures often, but when they got to the hospital, he was fine, something happened. And so there was never any medical documentation that he suffered from seizures. His doctor, no, so there was nothing there. But as I spoke to her, I found how real she was and truthful. And I said, there's something here, and I said, I decided that we would, we took the case and I represented her. And I remember that I was sitting there and they were holding hearings at the federal courthouse in Bridgeport. There's about 3 or 4 hearings going on. And the administrative law judge starts his opening remarks, and I'm sitting here, and then my client's here, and then there's a law student sitting next to me. And all of a sudden, he stands up, my client, and he starts leaning. And then a noise comes out. He got a seizure right there and fell to the floor. And what happened was, this is how he was able to win his hearing. Had he not gotten the seizure, right? Because his sister told me that, he said, Mike, when my brother is in a lot of stress, seems like brings on the seizures, and he was under a lot of stress being there, in front of the judge, and I think that was one of my all-time favorite cases because they were so genuine, and I think there was what really, I think the turning point was believing more the sister's story, because I really knew this woman and I know she was truthful, and I think that was one of my all-time favorite stories in legal services.
That was the best evidence in any case.
Yeah, that's right. Yeah, right.
Certainly passed the sit and squirm test, or the pain and squirm test.
Right.
Hey, Norman.
Yes.
You remember the Croson versus Fatsy case?
You'll have to remind me, Bruce.
The high school student.
Oh, yes.
The sick excuse for a mustache.
Right. Tell the story.
All right, that's another T. Emmett Cleary special. This boy was kicked out of high high school because the high school had a rule against no facial hair. And this, I guess he was probably 16 or 17-year-old boy, had this wispy, sad excuse for a mustache. So we brought a suit against the school district. It was in federal court, and it was before Clary. And of course, we knew we were up against it. The high school principal is on the stand, and I'm cross-examining him. And you know, when you're cross-examining, you're kind of building a box. And I had built my box, and I was about to swoop in for the kill when all of a sudden, out of the blue, Clary says, "Oh, we'll break for lunch now." Boom. But at that point, I'm just beside myself because I've already asked the principal, well, would my facial hair get me kicked out? Yes. Would Mr. James' facial hair get him kicked out? Yes. And we had another lawyer who also had facial. The long and short of it is, during the lunch break, apparently Clary finally read our trial brief, and we got back there, and before I could start even questioning the principal again, Clary interrupted and said, "Counsel, let me ask a few questions." He then asked the precise questions that I would have asked the high school principal, who probably would have tried to avoid answering my questions, could not bring himself to avoid answering the judge's questions, and the case was over.
It occurs to me that we may want to have a little conversation. We've mentioned a number of times that in these early days, we were litigating cases in federal court.
Yes.
Not disregarding Frank's story about using the procedural matters in housing court and in state court to change the law. But I think that the answer, I'm going to ask the question, but I think the answer is yes. But let's talk about why were we spending so much time in federal court versus state court, particularly on the affirmative kinds of cases?
I think there are two reasons. One, I think you don't think you had the filing fees, and secondly, most federal judges were more receptive to the issues. Now, on the state side, you couldn't appeal a criminal case without filing a filing fee. That was one of the first things that was litigated to get rid of it. So it was more difficult to get up through, and then the same thing about juvenile court. I forget what the rule was in a civil case. So it was more difficult to get into the appellate courts. But there was a good deal of litigation in state court, including the Connecticut Supreme Court. A good deal.
Yes, I think for every federal case, there were 100 state cases. And so most of the legal services lawyers spend most of their time in state litigation, housing, family, or something bankruptcy, or federal administrative Social Security appeals. So it wasn't every case. It was worthwhile
But
putting
in
it
the
together.
early days, the state judges were really very much opposed to
Yes.
legal services
Yes.
representation.
Yes.
And I remember the chief administrative judge in the circuit court saying to me once in chambers, "We know what to do with your motions for disclosure and for discovery. We just deny them all." And I said to him, "I know that." And that was just a matter of routine. So there was a lot of animosity. I mean, much of that is gone.
Oh, absolutely.
But in the early days, state court judges were anti-legal aid.
They were a different generation.
Yeah.
Yeah.
And they were probably from small practices, small picture.
You know, it's curious there, the initial opposition, not only from the bench for those reasons, from the bar for largely economic reasons and all, that was the kind of uphill fight we had in the beginning. But what really did the legal services in, when we got to the Reagan-Nixon and all areas, was a very simple phrase: why should I give you money to sue me? And it was the issue of the litigation against government agencies that I think really
Correct.
caused the big downfall in the end.
Right. Yeah, Miguel mentioned that Ronald Reagan, when he became president in 1980, one of his agendas was to defund the Legal Services Corporation.
And I don't know why they get away with all these restrictions, in an opinion by Justice Anthony Kennedy, they did away with one of the early restrictions where a lawyer couldn't talk constitutional law with his client in a welfare case, and he said that's just
Well,
nonsense.
as the
So why are there
restrictions,
so many restrictions? Why can't, isn't that a denial of equal protection?
you can get rid of restrictions, but the big restriction is funding. That's the fundamental.
Yeah, but there's still a bunch of others.
But I mean, even if you get rid of all these
Yeah, the
restrictions,
funding
how are
is
you
the
going to get the money?
Yeah,
Yeah.
yeah. Well, and
Right.
today, of course, it's even more serious.
We'll find out Monday.
Yeah, right. I wanted to say but just to put it in perspective, the sort of the legitimization of legal services over my experience. We told the stories about these beginnings of these programs and the fight we had in a lot of places with the bar and the reaction of the state court and the state government, largely negative. And by, I can't remember exactly the date, but it was in probably early 1990s when Tom Ritter was the Speaker of the House. And he, by the way, was the author of the IOLTA statute, the Interest on Lawyers' Trust Accounts, when he was chair of the Banks Committee. But by the time he was Speaker, and I think it was the early 90s, we're doing some kind of a training for legal services staff around legislative and policy advocacy, and we did it at the state legislature. They weren't in session, but we did it at the new legislative office building. And Tom Ritter hosted a reception at the end of the day, at the end of our training, for all of the staff. And I remember I was then still with Connecticut Legal Services, and I remarked, isn't this remarkable that the Speaker of the House of Representatives of the state of Connecticut is hosting us when, in that very early days, how much hostility we had from local and state government. Well, there's a sequel to that, 2 years ago, I think it was, Governor Malloy, now the governor, on his own initiative, hosted a reception in the Legislative Office Building for legal services, the Bar Foundation, all those who had been involved in this. And again, this is even a more remarkable thing because Tom Ritter's excuse was his wife, of course, was working for legal services and he understood us. But Governor Malloy doesn't even have that connection. But there's some I think that really, in that 40 years or plus, the change in attitude on the part of the state government, but we see the same thing. How many former legal aid lawyers are now judges?
Right.
Somebody mentioned earlier, and I think that's Howard, and other positions of real responsibility and authority in and out of government, I think is really a remarkable history.
And some credit goes to the law schools. Generations of law students now recognize the value of pro bono legal services, and that poor people can benefit from lawyers. And that's also became one of the major quotas of the bar associations. Some that you may say is public relations, but nonetheless it's established now. It's part of the norm. Poor people deserve representation by lawyers, and it's the proper thing for lawyers to do.
I want to mention that we talk about litigation and all that, and crucial, very crucial, but let's not forget, attorneys and paralegals that most of the time are out there representing folks, defending their, especially benefit programs, Social Security, welfare. This went on day to day. And let's not forget that part of our history, because that's something that is so much a part of legal service and what many of us would do day to day.
Yeah, the paralegals were workers in the vineyard. Without the paralegals, we'd just be in this law reform mode, completely devoid of much community contact.
Well, not just that, they really had a broad impact on what we were doing, because initially, with us, paralegals were out in the neighborhoods and were the immediate contact with people in the neighborhoods who, knowing the paralegal or being able to relate to the paralegal, would then come in.
Well, they were of the neighborhood.
They were.
And I think they're actually called neighborhood
That's right.
workers, not paralegals.
That was a term that
They're
we
very-
used at the beginning.
They're very good.
And what we found with the neighborhood offices in the beginning was, as was already been pointed out, that people who lived in that neighborhood would come to that office because of people like the neighborhood workers or paralegals, or because it was close by. But as a result of that, we were hearing about problems that people didn't think about as legal problems, like all these welfare problems came in just that way. And welfare law, as part of poverty law,
Well, many of us were going to
Develop
some of
right
these
there.
welfare mom groups that got together in the evening. We were a part of that also, and that's how there was that connection. We developed the trust and all of that. And all of that, Frank, what you mentioned is true because many of us lived there in the community, knew these folks.
that was critical for the success of the neighborhood offices.
Yeah, they were our eyes and ears. Left to our own devices, being law school graduates, we'd consider these wonderful principles, but they were the empiricists. They were the legal realists.
Yeah.
They let us know what was really happening and what problems needed to be addressed.
Yeah. When you looked at the Municipal Legal Aid Bureau in New Haven downtown, people would come down there who had been served with a writ, had to go to court, and so what legal papers went downtown. But in the neighborhood office, different stuff came into the office
Right.
that suddenly became to be known as or realized to be a legal problem, had a dimension to it that the law could address.
Yeah, it was. I kind of talked to a lot of my colleagues that I truly miss that. You learn so much, from these folks, day-to-day things that they experience. But it really, you learned a lot, and I will never forget, that connection. And sadly, in my personal opinion, I've missed that. I missed that in a big way, and I think as I speak to some of my folks that have been around, well, they feel the same way. It's not the same.
I think starting in the early days, there was an educational dimension to this. Because when you were working with clients, in many ways you were trying to teach them how to negotiate with your landlord, how to buy consumer goods, how to get credit, and how much of it stuck and how much didn't. But I think it was an important thing, because you think of it, who of us knew anything about the law when we got out of college or high school?
Or got out of law school even.
College or law school, yeah. Did you go to law school?
I did, yes, a long time ago. I think we probably are getting to the end of the patience of the audience who might be viewing this.
Sure.
So I want to ask if anybody has any sort of one final thought that they'd like to include in this recording.
Oh, it's a wonderful time, and it was a wonderful experience. It was very fulfilling, and I have no regrets for the 6 or 7 years I spent there, and obviously Fred and Frank and Miguel, who even spent longer time in the vineyards. Have no regrets.
Yeah, in that sense, we're fortunate in a way to be able to do something that is rewarding, meaningful, and that you can be proud of, to have engaged in it and worked with it. As I've done it longer and longer, I'm sort of bothered by the aspirational statement that we all sort of look to equal justice under law, because we see over and over and over again that access to the legal system is denied so many people. It really depends upon your wealth. In a sense, in a negative way, you buy your way in. So access is very limited, and equality. Even if you get access, you may not get full access, and so there are gradations. And so as much as we've done And as much as the scenery has changed, you see clearer and clearer how much more there is to be done if you're able to achieve that kind of a goal.
Huge.
Bruce or Howard, any final thoughts?
I've got just two, Norman. Each of us was involved in legal services at a really exciting time. It was exciting in that it was reasonably well funded. There were numerous issues that were ripe for resolution, and I think we all look back on those days fondly. Finally, I want to just thank you, Norman, for putting this together and being the person that you are.
Thank you.
Thank you, Bruce. Howard?
I've been listening very carefully to everybody, and I agree with everybody. It was one of the things that was said in an earlier conversation that we had, which got me thinking, was how young we were. The people who directed the programs, including and myself, were just a few years out of law school, and we were living in a time, and I think that's part of what has been developing in the conversation now, that we're living in a different time, but we were living in a time when there were counterparts all over the country, and it was a very dynamic period. We touched on things that had not been touched on before in the law, and it was a privilege. It was a privilege. I've always thought it was a great privilege to be a lawyer. I've never changed from that opinion. And my reason for wanting to be a lawyer was to contribute to justice. As corny as that sounds, it's true. And I know from listening to everybody else that everybody else in this group agrees. And we got paid for doing something we believed in. We got paid for learning, and we contributed something. I've come away from it with real thoughtfulness about what I've heard concerning the current state of funding, understanding that that's also true, for instance, here in California. It's quite true in the court system itself. The courts themselves are having trouble functioning because of funding. And I expressed the wish that we will see better days.
Thank you. I think that we'll call this to a conclusion. I will be remiss if I don't thank Wigan and Dana for giving us this room and their facility to make this video possible, and thank the Connecticut Bar Foundation for supporting this, both with some money but their time and effort as well. This is part of a larger project to do some individual oral histories with these folks here and others, and we're not sure how long it will go on or how many we'll do, but these kinds of conversations I think will be invaluable, and so for posterity we hope that it has been useful, and thank you very much.
Thank you.